All right, good morning, class. I'd like to welcome you to today's class. I want to believe we're all doing well and ready for this morning's lecture. I hope you can hear me. Please kindly confirm that you can hear me.
I hear you.
Yes, we can hear you.
All right. Okay, thank you very much. So you're welcome once again. And we are going to take off from where we stopped in our last class. And just by way of general recap, for the benefit of those who may be joining us for the first time, please kindly mute your mic. Please kindly mute your mic so that at least we can have some peace in the class. Okay? So we are currently looking at sources of Nigerian law, which is the topic 3 in the course content that we are expected to deal with in this semester. And under this topic, we have looked at the Nigerian legislation as one of the main sources of Nigerian law. And under that, by way of recap, we took our time to look at the legislative processes, that is, how a bill moves through the process to become law. And after that, we look at the received English law, which is also another major source of Nigerian law. And then, which is the point that that's the point where we are presently. And that is the subtopic that we are addressing. And in today's class, we are likely to wrap up the discussion on case law as a source of Nigerian law. And then we likely start with another one if time permits. But for purposes of creating a refresher in our memory, I want us to turn on the platform to talk to us, to give us a summary by case law or judicial precedent as a source of Nigerian law under the main topic of sources of Nigerian law. Is there anyone who will want to give us like a summary of what we have done? Probably talk about what case law or judicial precedent precedents, which is expected to lead to major subtopics like ratio decidendi, orbital dictum, and then the differences or similarities between the two, and also the types of binding,
Mary, mute your mic, please.
Can you hear me now?
Yes, sir.
Yes, sir.
I think I lost connection for some minutes. So I asked a question and I requested that someone should give us a brief rundown, more like a summary of what we've been talking about under the subtopic case law or judicial precedent. Is anyone on the floor that wants to do that for us? At least test what you think you have learned so far. That's one of the best way to retain it. Anyone? Okay, Williams, can we have you? Go ahead.
Good morning, sir.
Good morning.
Yes, sir. So, we treated case law, right? So, and you explained that case law or judicial precedent is a previous judgment documented by the courts used as judicial authority in subsequent cases sharing similar facts and circumstances. So then you went on to establish that the judicial precedent or case law is embodied in the Latin maxim stare decisis et non quieta movere, which means let it stand, or that the cases that has been, or what has been decided should not, be dismissed, or let me just use it like that. So you also further established that in the case of Pascal Incorporation Limited versus A.T. Kern, Esho held that the adherence to precedent is one of the strongest principle of the judicial system. Is one of the strongest principle in the judicial system. So then we went on to the nature of judicial precedent, where you established that judicial decisions are not made in vacuum, right? It's gotten from the facts, the judgment, and the circumstances surrounding the case, and that is where this judicial precedent are gotten from. Then we went to the discussion of ratio decidendi and what ratio decidendi is. And you established that according to Michael Sanders, it is a proposition of law which decides a case in the light of the context of the material facts that are submitted before the courts. Then that was when we were discussing ratio decidendi. I established that the court will look at the facts, the evidence, and the judgment and arrive at what is known as the rationale of the decision, which is ratio decidendi. So then we discussed ratio decidendi a little more. Sorry, okay. So we discussed ratio decidendi that you established that resting a decision on a valid point is crucial. So, and you established that ratio decidendi is the foundation of any judgment or ruling delivered, which is basically the key point, the reason for that decision, what the decision was about. And you said ratio decider is the most important part of a case. I remember my colleague asked a question about how we can actually find ratio decidendi, and you explained that that's the most important part of a case, that apart from the subsidiary, let me just use that word, subsidiary points made, ratio decidendi is the important part of a case. So it is the most important part we should remember or note anytime we're reading, the decisions or the judgment of the court in the case. And it is made of a material fact. So you said that what constitutes a binding precedent is the ratio, which is why. What is the reason behind this judgment? Why did this court make this judgment in this regard? Why did this lord or justice or judge submit in this regard? So, and that's what you made mention of under ratio decidendi. Then we went to obiter dictum, still under the nature of judicial precedent. We went to obiter dictum, and you said obiter dictum is a Latin maxim, which means by the way or in passing. So apart from the ratio decidendi, which are key aspects, I mean, not everything the judge says in a decision can constitute ratio decidendi. There are some statements that are made by the way or in passing or in addition to, that do not necessarily I won't say it doesn't contribute, because we can't dismiss obiter dictum, but are not necessarily part of the rationale of the decision, but they are still made mention of in a judgment. So and you held that when we have the ratio decidendi and the obiter dictum in the judgment, what is held to be binding or authoritative is the ratio decidendi and not the obiter dictum, because the obiter dictum is merely of persuasive effect. So I remember you explaining that obiter dictum includes explanation, analysis, illustration, opinions, and observations, hypothetical scenarios, and whatnot. And those explanations, analysis, opinions do not constitute ratio decidendi, rather they are obiter dictum, because they are made in passing or by the way. So then you distinguished between ratio decidendi and obiter dictum. And you held that ratio decidendi is the principle of law or the judgment, the principle of judgment, or the principle of law that is stated in the judgment on which decision, that particular decision is based. And that's I want to call it the substance of the decision, the substance of the judgment, the force behind the judgment. Upon what basis is that decision made? That's ratio decidendi. However, the obiter dictum does not necessarily form the basis of the decision, right? It is of persuasive effect, in that it's just to further broaden the understanding of the case or the scenario. So you gave an example of Donoghue versus Stevenson, where the neighbor principle now was made. So that neighbor principle was the basis of the decision in that Donoghue versus Stevenson, where you said that Lord Acton actually formulated the neighbor principle, that you must love your neighbor and you must cater, and that the defendant in that case has a duty of care to the people he's selling his drinks to ensure that there is no snail inside the ginger ale. So he has that duty. He has that duty to bear. So you explained that, and then you went to the types of precedent that we have. We have the authoritative precedent and the persuasive precedents. From the words, we can understand that authoritative means that it is binding on the courts. So ratio decidendi falls under authoritative precedent, while the obiter dictum falls under the persuasive precedent. So however, you establish that the court actually needs to distinguish between cases to make sure they are similar to distinguish between cases to make sure they are similar, so that the the principle of judicial precedence can apply, because you cannot have a case. However, the similarity does not have to be exact. I remember you pointed out it doesn't have to be exact, but there should just be like a way that the principle can be applied. So, for example, in the case of Donoghue versus Stevenson, the duty of care can be applied to somewhere else that might not even involve ginger ale, but they are still of similar facts. So it's a duty of the courts to distinguish between the facts to see if they are similar or they are not similar. So you also heard that the court is bound to follow a decision in Nigeria. This is in Nigeria. The court is bound to follow the decision of a superior court in the same hierarchy. So in the hierarchy of the court, where we have the Supreme Court as the apex court, a decision of the Supreme Court is binding on all other courts as judicial precedent. So in subsequent cases where such similar cases arise, the court, the inferior court are bound to follow the judgment of the Supreme Court. So okay. Well, I think one last thing I would like to point out is that where the decision is not made on reasonableness, or is made unfairly, or is not properly decided, it's still, if it's not properly decided, or it's, there's some, I don't want to say I don't know how to explain it, but if it's not properly decided, I feel like the judicial process will not apply if it's not properly decided, or if there's an element of illegality in the decision. So I think you made mention of that. Yes, and you established that the reason why the judicial precedent is actually exists is to ensure the predictability and the certainty of law, because law has to be certain. So there should be, although law, this does not actually excuse the fact that law is dynamic. Although law is dynamic, there should still be some element of certainty and predictability, so that you can know the consequence. If every time the law is uncertain and unpredictable, individuals will not know the consequences of their actions. So by virtue of the certainty and the predictability of law, people know that yes, if I do this, there are certain consequences that accrue to this, and there are certain things I will suffer if I do this. So yes, sir, that's it.
All right, Williams, I must appreciate you for this work you've done. Can I see your face? Can you? I like to see your face. Where are you? Okay. Yes, I'm impressed with the summary you've done, and I must commend you for that rundown. It was a very beautiful one. And if you don't mind, I'd like to pay for the data that you're using for this class. If it's not more than 5,000, I'm going to give you 5,000 naira.
Okay, thank you, sir.
For that summary you have done. So you send your account details to me through your class rep.
Okay.
I am impressed. At least I don't have any doubt that I have not done what I was. I have not done, and I didn't do badly in explaining what I explained. So thank you very much, and you need to keep it up. At the end of the day, I also want to see the grade you are going to come out with in this course, which must not be less than an A.
Yes,
Okay?
yes, sir. Yes, sir.
All right, thank you very much. So we'll take it up from here now. By looking at, I will only start from the disadvantages of judicial precedent. Even though we have established that judicial precedent as a source of law helps to establish some certainty, that we have also discussed in our last class. And then we also discussed some of the disadvantages, which we said that it has the effect of limiting judicial discretion. Because if a court is expected to follow a decision that has been reached earlier, the court only carries it and apply it once the facts of the cases are the same. So it is an argument that it may not give room for judges at that position to express their discretion. More so that when a case is going on, the court is looking at the actions of the parties. Sometimes even the courts may even know when a witness is even telling a lie. The court may also know when a counsel is trying to prevent his client from saying the truth. And then the court has a way of looking at, the countenance of everyone. And again, such actions helps to determine the outcome of the decision in some ways, even though we have established that the ratio decidendi is often, extracted from the fact of the case and the law that may be applied in the course of the proceedings. Yet, if a judge notices that the way a particular litigant is behaving suggests that, oh, this person is not saying the truth, the judge, it may reflect in the outcome of the case at the end of the day. So what a judicial precedent does at that point is that it doesn't allow that discretion to be exercised, because the fact that have been laid down accord with what was, used in deciding the previous case. So that is an issue. But at the same time, we know that judicial precedent helps to establish certainty. So, and we also establish that it may also lead in some cases to a premature crystallization of rules, when in fact they were still only in their formative state. In that, yet a judge may develop a rule, I said that earlier, and then if that rule has not been subjected to some analysis, if it has not been subjected to some reviews, it may contain some inadequacies, more so that no man is perfect. Even the revered justices of the Supreme Court, both present and past justices, even with their erudite judgment and submissions, they are also not very perfect. So when such rules are developed and the judge is applying it, suddenly it may just, especially if it's from a higher court, it may become a rule that is supposed to be followed. But be that as it may, we also see that as a form of disadvantage to it. And such errors may just continue to linger on in the process. Now, there is obvious antithesis between rigidity and growth. Now, what do I mean by that? One thing we said about judicial precedent is that it helps us to maintain certainty. Certainty may now talk about rigidity. That is, the court has said this, then we must follow this. But again, sometimes this, even when we have to apply judicial precedent in that line, when there is need to do what we call distinguishing, or to actually see whether the facts are the same, there are ways in which the court can adapt, or the court can also deviate in the spirit of justice to ensure that, the right thing is done in the course of the proceedings. But also, we also know that sometimes, even when the judges may feel that this case is not in all four similar, or the facts are not similar to the present one, the judge may seek distinctions. That's one thing about what we are saying. The court may now say, okay, now let's look at the difference between this case and this present one. It may be a call from counsel or lawyers who is appearing before the court to bring to the notice of the court and say, my lord, I do not agree that this case is on all four the same with the case at hand. Therefore, there is need to do what is known as distinction. Or bring out the facts, put them side by side, and see how it can be established whether they are the same. So sometimes they may discover some aspects that are not completely the same, and then that may help the court to do what is expected at that particular point in time. So, but what we emphasize here is that for this decision, for the judicial precedent to be binding on a similar case or another matter on a lower court, the facts must be the same. You cannot take away that particular position. And then, if the facts are different, it is also important that the principle which govern the first case is applicable to the variant facts. What it means is that once a distinction has been done, and then there is need to separate the fact from what is being applied, the courts can, look at the principles and see how to do justice in order not to apply the previous case to bring about injustice in the proceedings. Then also, in this instance, the judges decide whether the situation is comparable or not before judicial precedent can be binding. So whether the court is going to follow it or not, the decision lies with the judge, who, in the course of his judicial assignment, look at whether or not they are the same or the two are not the same. And with that, then the court is able to come to a conclusion that, whether this particular case should be applied or not. But all is geared towards establishing that justice is served in each case. Now, let me, in relation to distinguishing the facts of the two cases, let's look at the case of London Street Tramways versus LCC. Okay, this case will tell us more about this point that we are trying to make. In the case of London Street Tramways versus LCC, in this case, the House of Lords firmly established the principle that it was bound by its previous decision, but it was prepared to depart from an earlier decision made in ignorance of existing statutes. So what we are saying here is that there was a particular statute that ought to have been considered in arriving at the judgment in that case, but that particular status was not put into consideration. Now, in a practice statement that what is raising the hand, Oreoluwa, you have a question?
sir. And we are 100, some 100 level students don't really understand what we're talking about.
You
Because
said
this is not
what?
where we stopped at our last class. I said some 100 level students don't really know what you're talking about because this is not where we stopped at in our last class.
Now you should apply your mind to where we are. The reason why you are joining this class, like I told your coordinators, the present level that I'm addressing, they're already ahead of you. But you are still going to take this topic later on. So the advantage you have now is that you are taking this particular topic and I'm still going to teach it when it gets to your own time. Remember, we just started for your level. But since the lecture is online, I feel that you can benefit if you listen to this aspect so that by the time we are teaching it again, you are able to, relate to what we are talking about. And I remember I sent your course outline to you. And if you look at that course outline, you notice that we are on topic 3. So if you are doing topic 3 now, part of topic 3 is an advantage for you just to have an idea of what we're talking about so that when we get to topic 3 in your own time, it will give you more understanding. So all you just need to do is to follow us. Okay, you may not understand everything, but if you started from the beginning, you will have a better understanding when we have to do a review of what we have been doing before. So there's nothing to worry about. You are still going to do the topic again. Yes, Taiwo.
Okay, sir. Thank you, sir.
Good morning,
Yeah,
sir.
good morning.
Sir, you made mention of a case. Please, can you repeat it and what you said about it?
No, the case is London
Thank you, sir.
Street Tramways. London, and you should be able to spell that. London Street Tramways is a name of a company versus LCC. Like I said, the House of Law, that is the court in that case, firmly established the principle that it was bound by its previous decision. Okay? But it was prepared to depart from an earlier decision made in ignorance of an existing statute. Meaning that when the case was to be decided, the court did not avert its mind to a particular statute, which ought to have made the judgment to have come in a different way. But what we are saying is that the court was ready to depart from that earlier decision. Because the core of this is that judicial precedent, once a judgment is reached by a higher court, it is binding on the lower court in a similar case with a similar fact. But we are now saying that there are some times that the cases or the fact of the case may not be completely the same. And then there is need to look at the differences. Where the differences can be established, the case may not be applied totally. Okay? So that was where we were before the questions came. All right. So now I will move on from where I stopped earlier. So I was talking about the fact that in that case, London Street Tramways versus LCC, the court was willing to depart from the earlier decision that it was required to apply because of the fact that that decision was reached without considering a particular statute that ought to have been considered. So now there's a particular judge, Lord Gardner. He was speaking for the Lords of Appeal, an appeal in this particular case. And he said, in like a reference to what we are saying here. He said, their lordship nevertheless recognize that the rigid adherence to precedent may lead to injustice in a particular case, and also unduly restrict the proper development of law, but that they propose that there is need to modify the practice of precedent. All of this is just to still portray the fact that if the facts of that case is not the same with the present case, there will be need to, to adjust the practice. Adjusting the practice helps the court to arrive at justice, because justice is therefore justice is the ultimate in all of these situations. So what it means therefore is that if it is perceived that complete application of that previous case in the present case may lead to injustice, Lord Gardner said that there may be need for the precedent or the practice to be reviewed in order for justice to be served at the end of the day. So, based on this position, the House of Lords has ceased to be, bound to follow its own decision, especially if the decision appears not to serve the end of justice. So in all of this, application of judicial precedent may not be total if the fact of the two cases are not the same. That's all that we're trying to say. Now, let's apply all of these things to our own system here in Nigeria. For the benefit of all, the highest court in Nigeria is the Supreme Court, followed by the Court of Appeal. So, applying the doctrine of judicial precedent, it simply says that the decision reached by the Supreme Court in a case is binding on the Court of Appeal in a similar case. That's simply what we are talking about. So, like in Nigeria, like I said before, the Supreme Court became the court of final appeal, that is the last court, in 1963, when the appeal to Privy Council was abolished. And then the Constitution has provided that no appeal at all shall lie to any other body except the Supreme Court of Nigeria. And that's why I said, if you are not satisfied with the decision from the Supreme Court, you may likely appeal to God. As far as Nigeria is concerned, the Supreme Court is the highest court in the land. So, by virtue of that position, the Supreme Court is binding. The decision of the Supreme Court in any case is binding on all courts in Nigeria. But it is not in turn bound by the decision of the Nigerian court. What it means is that the Supreme Court's judgment is binding on all courts, but the decision of other court is not binding on the Supreme Court, because the Supreme Court is the highest court in Nigeria. Again, the Supreme Court, being the highest court, is not bound by its own previous decision, nor by the decision of the Privy Council after 1963. What that means is that the Supreme Court may have reasons to depart from an earlier decision that has been reached. Just like William said in the course of his summary, that if it is discovered that that decision was reached an error, the court needs to do justice by ensuring that the error is corrected one way or the other. So the court may feel compelled to review that judgment. So what it therefore means that this practice of case law binding or not binding is not statutory, meaning that the Supreme Court may review such situation if it's confronted by it. And again, it can also be said that the Supreme Court enjoys a measure of judicial sovereignty comparable to some extent to parliamentary sovereignty. Now, what we are saying is that the Supreme Court may alter or may remodify if need be, but other courts cannot do that, especially other lower courts. So, meaning that Supreme Court may depart from a case law in the interest of justice and in order for proper development of law to continue. And that's why Obaseki JSC made a quote, which I want to read to you now. According to Obaseki JSC, it is settled law that this court, he was referring to the Supreme Court, has jurisdiction to depart from its previous decisions. It has been restated in Paul Odi and another versus Gbaniyi or Shafile and others. I'm reading what the court said, where the court affirmed that there is unanimity that the Supreme Court, as a court at the apex of judicial hierarchy in the country, has the jurisdiction and power, sitting as a full court of 7 justices, to depart and overrule previous erroneous decisions on points of law given by a full court on constitutional question or otherwise. So what the court, according to Obaseki JSC, was saying here is that even though the Supreme Court is the highest court in the land, for the purposes of developing our laws, for the purposes of ensuring that justice is served, and especially in matters that relate to law, the Supreme Court may make amends where judgments must have been reached in error. And what this means is that it's a confirmation of the fact that the Supreme Court is infallible. You know, like what we have, let me read this to you. He said, this is a confirmation of the authenticity of the statement that the Supreme Court is infallible because it is final. But it is not final because it is infallible. What that simply means is that the Supreme Court can also make mistakes. The Supreme Court is not final. But even though, the Supreme Court may not give a perfect judgment, because of course, it is human beings that sit on those cases. So they can make errors. But that's not what makes them to be a final court. What makes them to be a final court is because the Lord has said so, that the Supreme Court is the highest court in the land. So they can make mistakes. But what will become an issue is that after the Supreme Court has discovered that it has made an error in a particular case, is to allow that error to continue. Then the Supreme Court may not be serving the right position as the highest court in the land. The Supreme Court should be able to correct such errors for purposes of the development of law and also to ensure that justice is served. So this is how this particular topic relates to the Supreme Court. Now let's move down to Court of Appeal, which is a court that is following the Supreme Court. And the number one thing we need to mention here is that the Court of Appeal is bound to follow the decision of the Supreme Court. All other courts similarly follow its decisions. If the Supreme Court has given a judgment, by virtue of this doctrine of judicial precedent, the Court of Appeal is bound to follow it. Just the way all other courts below the Court of Appeal is also bound to follow the decision of the Court of Appeal. Okay? Now, in the case of Young versus British Aeroplane Company, this is a case that was decided in 1944. Young versus British Aeroplane Company Limited, decided in 1944. Lord Green, a justice of that court, said that the English Court of Appeal is bound to follow previous decision of its own, as well as those of courts of coordinate jurisdiction. Now, that is an aspect of what we're talking about. Now, if there is any other court that is at par with Court of Appeal in Nigeria, of course, there is none like that. In the English system, just like what we saw in this case, the Court of Appeal will have to follow that decision. But for us here, the Supreme Court is higher. The Court of Appeal is bound to follow the decision of the Supreme Court. And so also, all other courts below the Court of Appeal is expected to follow suit. What about how the case relates to the High Court? The High Court is also like the third in hierarchy. High Court in Nigeria follows the Court of Appeal, if we are to arrange it in some way, while the Court of Appeal, follows the Supreme Court. So the High Court and other subordinate courts are bound to follow the decision of the Court of Appeal and also the Supreme Court in that hierarchy. And their decision also is also binding on inferior court. Now, one thing you will have observed by reason of this hierarchical division that we're talking about is that while the decision of Supreme Court is binding on Court of Appeal, Court of Appeal's decision is also binding on the High Court, which is a court below it. But like we said in the case of the Supreme Court, that the Supreme Court may choose not to follow its own decision, may amend it. There are also exceptions in the cases of High Court or even Court of Appeal, where the court may also, not follow the decision stricto sensu. So, under this exception to the rule, a court may decline to follow a binding precedent in a situation where it is unable to distinguish a case before it on its fact from the case that is making reference to. if the case, the previous case and the present case, the court is unable to distinguish the facts, then the court may not follow it. Because whether we like it or not, the underlying factor in this case is that the two cases must be the same before it can be applicable. And this particular situation is very important. So where the case cannot be distinguished, or where the court is not able to look at whether they are the same or not, the court may not apply it. Because the court at every point in time seeks justice. So that is exception to this general rule. The general rule is that the lower court is bound to follow the decision of the higher court. But we are saying that, because you may be asked in an examination that, what are the exceptions to this rule of the bindedness of judicial precedent? You should be able to establish that a court may decline to follow binding precedents if the court is unable to distinguish between the two cases. That's one. Number two is that where the ratio in the precedent is considered to be obscure. If the ratio decidendi in that case does not, really accord with reason, or is something that is strange, is something that does not accord with, normal principles of law, the lower court may not apply it. That's number two. Number three is that where the precedent is in conflict with a fundamental principle of law, the court may decline to apply it. This is a major fact to note in all of these our submission. Number one, I repeat that exception to the general rule is where the lower court is unable to distinguish between the two cases. Number two is where the ratio in the precedent is considered to be obscure. Number three is where the precedent is in conflict with a fundamental principle of law. The court is enjoined to decline applying that doctrine of judicial precedent. Because like I said, the purpose of it is to get justice done and not to satisfy anybody. Okay? Now, I think there's someone raising his hand. Jeremiah, let's have you.
Good afternoon, sir.
Good afternoon.
The second exception you mentioned,
Yes.
doesn't that actually go against the fundamental principle of the judicial precedence itself? I think the fundamental principle of the judicial precedence makes it that jurists in higher courts probably have more experience and are generally more learned than jurists in lower courts. So how will a jurist in a lower court be able to say that a ratio decidendi of a decision by a higher court is obscure and decide not to apply it? Okay,
now let me tell you what the meaning of obscure is so that I can respond to you appropriately. Now, the dictionary meaning says not clearly expressed or easily understood. Now, I get the point that a lower court may not really be able to question the reasoning of the higher court. But where the lower court feels that I do not understand this ratio, it's not clear to me. The ratio is not clear. It's not easily understood, probably because it has some ambiguity in it. The court, for the purpose of doing justice, may choose to decline, but it doesn't mean that another judge, another court will not apply the same precedent, because we have different understanding when it comes to this. Was I able to answer the question?
Yes, sir. Thank you, sir.
All right, thank you. So Collins, let's have you.
Good afternoon, sir.
Good afternoon.
These exceptions that you have listed, are there like cases that this were manifested?
Yes. I'll give you the cases, but you go read it up yourself. For the exception number 1, in the case of Foakes versus Beer, Foakes is spelled Foakes versus Beer, Beer, reported in 1884. You may Google this, and then there's another case for that exception number 1. It is known as the High Tree case, reported in 1947. For the exception 2, I do not have a case for that. But for exception 3, you can take the case of Young husband versus Luftig. Young husband, as in young, then husband, versus Luftig. Luftig is spelled Luftig, reported in 1949. But the case is popularly known as Young's case. You may also Google that to get more facts on it. Yes, David Badamosi, let me answer you before I go to the next point.
Sir, please, can you please just repeat the first exception that you said? I did not quite hear that. My network was breaking up.
Okay, the first exception is that if the court is unable to distinguish the case before it on its fact from the facts of the binding precedents. Simply put, if the lower court is not able to distinguish between the fact of the present case and the binding precedent, the court may choose to decline its application. The number 2 that I said is that where the ratio in the precedent is considered to be obscure, that is, it's not clearly expressed, or not clearly, not well understood. The third one is where the precedent is in conflict with a fundamental principle of law. The court may decline the application of a binding precedent. Number 4 is where there is split judgment. Okay? Where there is split judgment, the court may also decline to apply that. Now, where there is split judgment, what do we mean by that? There are cases where there may be 2 judgments, where we refer to one as probably main judgment and dissenting judgments. A dissenting judgment is a judgment given contrary to the main judgment. Let me put it that way, in a simple way. Now, these kind of decisions are common in higher courts. For example, maybe Court of Appeal or the Supreme Court, where we have many number of justices sitting at the same time. All the judges may not agree with the overall judgment. So where the court does, where all the justices do not agree, another judge is also at liberty to give what we call a dissenting judgment. So where there is split judgment, the courts in the lower court may feel that, oh, the two justices may have provided reasons for their decisions. And then applying just one to the present case may not bring about justice. This is another exception to the application of binding precedent. The fifth one is where the decision is reached in ignorance. Okay? Where the decision is reached in ignorance. Recall that I mentioned earlier that in the case of London Street Tramways versus LCC, the court was ignorant of a particular enactment and went ahead to give judgment. So that judgment needs to be revisited by the court of that hierarchy that made it. So where that decision is reached in ignorance, the lower court may choose not to follow the decision. Yes, Obi, let me have you, followed by Adeleke.
Okay, so in the exception, the first exception, you mentioned two cases. The second case, the one that was recorded in 1947, can you please state it again?
The
Thank you,
second
sir.
case is, I said, is the I3 case. I as in H-I-G-H, then 3, T-R-E-E case, I3 case. Are you okay now?
Yes, sir. Thank you, sir.
All right, Adeleke, let's have you. Adeleke, I can't hear you. Okay, let's move on. Can you unmute now? Adeleke, I've given you permission to unmute. Can you speak? Okay, Charlie, let's have you.
Good afternoon, sir.
Good afternoon.
Sir, regarding number three exception, so I just want to know why will the higher court, like the Supreme Court, give a judgment that is contradicting or that contradicts the provisions of the Constitution? Because that is that point 3, that exception number 3, that is how it sounds to me, that they are giving judgment and the judgment is not in accordance to the provisions of the Constitution. So why would judges of such
don't get me wrong. Don't get me wrong. Don't put words in my mouth. I didn't mention the Constitution. Okay? Once the Constitution is mentioned, then if a judgment is given contrary to that, already that kind of judgment is already it's clearly, against what is expected. But what I said is that where it is given in conflict with fundamental principles of law, it can be any law. But you know that, now let me bring it home. Let's be practical. We hear of some judges that are corrupt. These judges, how do they achieve their aim? Sometimes they achieve their aim by ignoring obvious facts, by ignoring obvious laws. Anybody that is set out to do evil will ignore the obvious. So where such occurs, because of course we have had where people obviously go, they go against the obvious. Then it's one way or the other, the court may still have to come back to it, especially if it's happened in the higher court. If it happened in the lower court, the higher court can revisit it and overturn the judgment. Are we okay now? Okay, Giwa. Giwa, can you give your question? Can you ask your question?
What if the lower court they have a different perspective on the case? Are they still bound to follow the decision of the Supreme Court?
Now, a different perspective in what sense? We are talking about facts here. Once the facts are the same, the court is bound to follow it. But the exception to it are the things that we are looking at. So if your question does not fall within this exception, then there may be no justifiable reason for not applying it.
Okay.
Yeah. So let's move on so that we can cover the exceptions in the course of this class. So the fifth exception, like I explained earlier, is where the decision is reached in ignorance. The court may decide not to follow it. Another reason, another exception is where the precedent was arrived at. Who is this?
So I don't tell am say I miss you. You gonna talk say all right, thank you. I gonna talk say all right, thank you. You gonna talk say okay. What the fuck? Are you trying to provoke me? Are you trying to get like an sorry, my
Wait, is it because of 8K, 2K?
As this
No,
consular,
I said that one no. I thought they don't come and see me like kiss me. I think that's me do a video first.
can you see your colleague?
That's what
Mute yourself. Aziz coin so
I
I
got
might
my phone tell him, I go tell him, I say, wait.
coin so mute yourself.
It's such a shameful thing, but it's okay. All right, so let's continue. And that coin solar is unfortunately bearing the same name with the good coin solar that is participating in the class. All right, I will attend to your questions. I would like to finish the exceptions in this class so that we can be able to make progress. So just hold on, I will call you at the right time. So the other exception that I've made mention of is where the precedent was arrived at per incurium. Per incurium, the per is PER, incurium is INCURIAM, incurium, that is through lack of care, as where the precedent which would have affected the decision was not brought. So just like when a judge was not careful enough, that kind of judgment is deemed to have been reached by incurium, and therefore it will not serve the end of justice if the lower court should continue to apply such. It's like one is spreading injustice continuously. Okay? Then another exception is where the court declares that the ratio of the precedent cited was too wide or decided on a special facts. What that simply means is that they are not of the same.
Sir, please can you come again?
That exception says that where the previous decision, where the court declares that the ratio of the precedents cited was too wide or decided on its own special facts, the court can decline to apply that precedent. That's number 7. Now, what I said about that is that means that the facts are not similar. Once the facts are not similar, a lower court will choose not to apply it. Now, something just came to my mind, which I think I should make you understand. Now, when a judge wants to apply a case to a present case, the court can do it on its own when writing the judgment. Also, a litigant, a lawyer, can also be the one bringing it before the court to say, my lord, in the case of John and John, the court heard that where Mr. A fails to do this is liable to this. So either the court can import it, or the lawyers that are appearing for their clients can also bring it up. But whichever case, the court, like we said earlier, has the final say on this position, because it is the duty of the court to review whatever it is that is presented before it. So where the facts are not similar, the court will not apply it. Now, exception number 8, is that where the previous decision is one of several conflicting decisions made by a court at the same level. Okay, I'll repeat that again. This exception says a court may decline to apply a binding precedent where the previous decision is one of several conflicting decisions made by a court at the same level. The court may choose not to. Now, there was a time in the history of this country, particularly in Rivers State, where decisions of courts of the same level were just coming out like day after day. Maybe based on whatever reason, I wouldn't know what was happening, but it was obvious that this litigant will run to this court. Today, they will bring out a judgment. Another litigant on the same matter will go to another court. They will give a different judgment on different principles. That is one other ground where a court may choose to decline to apply a binding precedent. Another exception, number 10. It is important that you take note of these exceptions. My spirit is telling me to tell you. So, exception number 9. The court may not apply a binding precedent where the rule of law contained in the previous decision is overruled either by statute or a higher court. The court may not apply a binding precedent where the rule of law contained in the previous decision is overruled either by statute or a higher court. Now, let me explain that to you. If, for example, the Court of Appeal has given a judgment, and that judgment is now constituting a binding precedent on high court, but before the high court could complete its activities, the party in the Court of Appeal case went to the Supreme Court, and the Supreme Court overruled the judgment of Court of Appeal. Automatically, the high court cannot apply that decision because the the higher court has overruled that decision. You can look at the case of Act, HACK, versus London Providence Building Society. Act versus London Providence Building Society, reported in 1883. That is another case you can Google or look up to get to confirm that point that we have just made. Number 10 exception. Oluyinka, please note your question. I'll give you room to ask that question later on. Number 10, the court may choose to refuse or decline to apply a binding precedent where the Supreme Court must have departed from that earlier decision. For example, the Supreme Court has given a judgment now, and then a litigant is now making submission in the lower court that this is the position of law as stated by the Supreme Court. Meanwhile, the Supreme Court has already departed or has already amended that law. This is also similar to the one that we discussed earlier on. Now, in this case, the lower court may now have reasons to look at the variation that has been done so that it does not apply a law that is not profitable to that present case. Because just like judicial, our laws are growing, cases in courts are also growing. Also, decisions that are reached can also change, which is also part of growth. Okay? Then the court, for the sake of doing justice, may choose to depart from, that particular position of the law. Now, let me take Janet before I'll conclude the class. Adeleke.
Sir, I wanted to ask about the fourth point you mentioned. I didn't get the explanation where you said the lower courts might decide not to apply the precedent if there is a split judgment.
Yes. And I explained that there is what we call dissenting judgment. Did you get that when I was explaining?
No, sir.
Okay. In Court of Appeal, for example, where we have about 3 or 4 justices that may sit on a particular matter, the lead judge is the one that is expected to give the lead judgment. But all the other justices are not bound to agree with the lead judgment because they are at liberty to also reason differently. So what that means is that the dissenting judgment is allowed to stand side by side of the main judgment. But the lead judgment or the main judgment carries the day. It doesn't mean that the dissenting judgment should be discarded. But what we are saying is that for the two of them to arrive at two different decisions, they have reasons, they must have advanced reasons for their decisions. Those reasons may be valid, but the majority of the justices determine who wins the day. So if, for example, we have about 4 justices presiding on a case, 3 gives a judgment that is 1, while 1 person gives a dissenting judgment. That judgment, the one that has 3 in 1, will be the one that will carry the day. Do you understand now?
Yes, sir. But does that mean if the lead judgment goes against the other 3, the lead one is one that will rule, or is just majority carries the vote?
What makes, yes, majority carry, let's just use that. Majority carries the vote.
Oh, okay. Thank you, sir.
All right. Yes, Oluyinka.
Okay, sir. Confirm if this illustration aligns the section of number 9. In the case, sir, hear me?
I'm struggling to hear you. Can you repeat?
Okay, I said I want to confirm if this illustration I'm about to give aligns with that of exception number 9. So in a
Okay.
case where there is a case in court, like the illustration you already gave, in the court of appeal, where the appeal gives a decision on a case, and before it was appealed to the Supreme Court, a case is already in the High Court trying to, use the same facts of that of the decision made in the appeal court. So now in a situation where in the Supreme Court, the case taken to the Supreme Court is a totally different one from that in the appeal court, but the same facts. And the Supreme Court gives another decision that is different from that of the Court of Appeal. So I want to confirm if that's the decision of the Court of Appeal is actually going to be, is going to be cancelled. Yes, something like that.
Okay, that if the case taken to the Supreme Court is of a different fact, is that not?
No, not different fact, a different case, but similar facts.
No, you are getting it wrong in that point. The case that is in the High Court, they must have cited that it is the case of Ojo and Tinubu. That is what the High Court is considering. And the High Court is considering the judgment of Tinubu and Ojo from the Court of Appeal. And we're now saying again that the Tinubu and Ojo has left Court of Appeal to Supreme Court.
In this case, they are not leaving the appeal. Let's say it was finalized in the Court of Appeal. Yeah, like I know you gave the example of it being taken to the Supreme Court, but I'm not saying what if it was never taken to the Supreme Court it was never appealed. The case was never appealed, and there is another case taken to the Supreme Court, a separately different one, but the same similar facts with that of Ojo and Tinubu. Do you get what I'm trying to say?
That case, that entirely new case, if it is of the same fact with the one in the High Court, the one that is in the Supreme Court will prevail.
Okay.
Because that decision is now coming from another higher court, higher than Court of Appeal.
All right, sir.
You get it now?
Sir, please, on this, sir, please, if the High Court never gets to know about the new case in the Supreme Court, would anything happen to the case of the Court of Appeal?
No, the Court of Appeal's case will still remain the final judgment on that case. Do you understand? Can you hear me?
Yes, sir. Sir, please, I have a question.
Go ahead.
Okay, sir. You were speaking about on the 10th point where you said that the Supreme Court can depart from an earlier decision to ensure justice, and when it has already been amended, the lower court. Okay, so I wanted to ask that once it has already been amended, does it invalidate the earlier decision? Like if the SC after some time a new case is brought before it and they review its own previous decisions, and in the High Court now the council brings the old decision that has not been reviewed, does it mean that if the high court gets to find out later during the case that SC case has been reviewed, does it mean that it will completely invalidate
Yes, it
the
will validate it. If it's on the same fact, on the same principle, the earliest one from the Supreme Court will take the reign. Do you understand
Okay.
now?
Yes, sir. Thank you, sir.
Yeah. All right. Who else?
Sorry, sir. Good day, sir. Sir, does that mean that cases will be recalled? Is it
Recall
possible for, like, okay, they found out that the decisions that they've made was not in tandem with the new decisions, like it has been reviewed in the Supreme Court, and then now there is a new judicial precedent. Yes. Does that mean that maybe other decisions that were made with the former precedents would it now be recalled?
That is if they choose to appeal on it and now apply the new case, then it will be overruled. But if they don't, if the parties did not appeal or did not see any reason to revisit the case by appealing, that is even if the time within which to appeal is still very available. Are we okay now?
Sir,
Yes, sir. Thank you, sir.
sir, I have a question.
Yes.
So you talked about two types of judgments in the number 4 section. You said something about dissentive judgment. I didn't really get what you said about it. Can you please explain it again?
When you have like 7 justices sitting on a particular case, they are hearing the matters from the lawyers. They are taking their records. Okay? As they are taking their records, they are having different reasoning on what is being said, and they are making their notes. And then, at the end of the day, they write their judgments. But they compare notes. At the end of the day, 5 of them may have the same reasoning and have the same judgments. And one of them will be read, which is the lead judgment. That other one that does not agree with the rest of them is a dissenting judgment. It's let's just say a judgment with a different view. That's the common language you can use. But it's also a judgment. It's also a part of the whole procedure. But the lead judgment, the main judgment, which is of the majority, carries the day. Okay? So with this, we'll have come to the end of case law or judicial precedent as a source of Nigerian law. And sorry, I won't be able to take other questions. The class is supposed to start now on this same Zoom account, so I'm delaying that class. I'll need to go. But you can send your message to me through your coordinator. I will send answers to you as time
You have not
permits.
taken that, sir.
Okay, yeah, that's correct. Oriade, please get me the account details for Williams.
I've sent it to your WhatsApp, sir.
All right, that's okay.
Yes, sir.
Let me put the chat box now so that you can send in your.
Yeah, 5,000. Nice. Ẹ̀wọ̀n kàn lecture ẹ̀ máa ń lówó lọ́wọ́. Lọ́ọ̀yà ni máa yìnbọn ṣe wà yìí. Wọ́n lecture ẹ̀ máa ń lówó lọ́wọ́. Ṣé o mo gbà láyé mi?
That does the agenda also have to do with the
So please, you can send in your.
year one as well.
Just type in your number, your math number there. Don't worry. Just type in your math number. If you don't have your math number yet, type your name and your department. That's all. It will be sorted. Is that taken? All right. So thank you for joining the class. We call it a day here. And by God's grace, we'll reconvene in our next period. Thank you very much and enjoy the rest of your day.
Thank you, sir.
Thank you very much, sir.
Yes, sir.